Good evening all. Which topic was? Okay, let's write this. As I told, I think broadly Article 21 we have discussed in and around that how they ask questions. Almost 4-5 questions have been asked. So let's look at Article 19 angle. Again, because freedom of speech and expression is a very broader one. Twice they have already asked a question, this and this. Or if you add residence and freedom of right to movement and residence, then it is 3 questions on Article 19. But most importantly, freedom of speech and expression is our concern, because that is where you get very high chance of question. Please note this one. This will become a kind of your content also, plus answer also. Okay, na? This is, you have very less chance of this same question getting repeated, but the arguments can get repeated, because anything in and around freedom of speech and expression, you can use the same arguments. Section 66A of the Act with reference to its alleged violation, clearly they are asking Article 19 of the Constitution. Fine. Now, if you can recall what was Section 66A? Recall what was your Section 66A of IT Act? First, because clearly remember, as I keep telling, if you have a keyword, then it's better you talk about this in the introduction itself. You have a clear keyword here. First, write about that in your introduction. Section 66A of IT Act. Section 66A of IT Act provided that, or mentioned that. Section 66A of IT Act mentioned that spreading any information using a computer device which is grossly offensive. So those are the keywords, which is grossly, G-R-O-S-S-L-Y, which is grossly offensive, annoying, A-N-N-O-Y-I-N-G, which is grossly offensive, annoying, or malicious, kind of bad intention, trying to hurt someone, or malicious, will be considered as a criminal offense. So that was actually the provision. Fine. Now, what did Supreme Court do that? That you have to refer. Which case? Landmark case again. Supreme Court in Shreya Singhal case. Supreme Court in Shreya Singhal case declared Section 66A as unconstitutional. Declared Section 66A as unconstitutional for violating obviously which one? Freedom of speech and expression under Article 19 Clause 1 Subclause A. For violating freedom of speech and expression under Article 19 Clause 1 Subclause A. Now that is a core. Violating freedom of speech and expression under 19 Clause 1 Subclause A. Now obviously what are the other arguments also you have to give here, because you can't just, they have only clearly told, but what else, but why did Supreme, you have told that yes, they have declared it for so and so, but what was the reasons? For that concerns you have to write criticisms against Section 66A. Why actually the reason, rationale you can say, criticisms against 66A. Obviously, first point is what? The words mentioned are very vague. Remember, we normally keep using these words. The words mentioned are very vague. Hence, automatically, whenever it is vague, what is the chance? Chances of misinterpretation is very high. The words mentioned are very vague. Hence, chances of misinterpretation is very high. Hence, the chances of misinterpretation is very high. Hence, the chances of misinterpretation is very high. Point number 1. Point number 2. It has a chilling effect on freedom of speech and expression. Chilling means it will curb. Those are the keywords that you have to continuously use. It has a chilling effect. Chilling effect is the keyword on freedom of speech and expression. Chilling effect on freedom of speech and expression. If you want to add another keyword, which is what? Which is part of golden triangle of Constitution. Which is part of golden triangle of the Constitution. Part of the golden triangle of Constitution. That's another one. Next one. There are no procedural safeguards because they can easily come under arrest. Actually, procedural safeguard means minimum inspector should give the permission, DPSP should give the permission, like that. There are no procedural safeguards with respect to section 66A. No procedural safeguards with respect to section 66A. Hence, misuse is high. That is actually Supreme Court statement itself. Hence, misuse is high. Fine. And again, next another one is what? It was misused against opposition and journalists. It was misused against opposition and journalists. Against the opposition and journalists. Fine. These are all arguments why it was criticized. You can also counter argue. However, section 66A was also or was needed. However, section 66A was needed to tackle misuse of technology. It was also needed to tackle the misuse of technology. Fine. How can you say that? First argument, again counter there. Freedom of speech and expression is not what? Absolute. Article 19, clause 1, subclause A is not absolute. It has reasonable restrictions. So public order you have, morality you have, incitement of, so many are there. It is not absolute, it is subjected to reasonable restrictions. So hence you could have restricted that. Fine, that is 1. 2. Impact of social media. Impact of social media is very significant. Impact of social media is very significant in the era of fake news, deep fake, etc. It is very significant in the era of fake news, deep fake, etc. And then introduction of procedural safeguards would have reduced the misuse. So why are you unconstitutional? You are declaring it as unconstitutional. Introduction of procedural safeguards would have balanced or would have narrowed, whatever. Introduction of procedural safeguards would have balanced the scope of 66A. Balance the scope of 66A. Right? So that is broadly. So then what is government trying to do? Government wants to, broader conclusion part you can say, government wants to reintroduce, means bring back. Government wants to bring back section 66A. Government wants to bring back section 66A to address emerging challenges. To address the emerging challenges. But actually what is needed? Holistic reforms of Information Technology Act is the need of the hour, because the original act was in 2000. So it's already too much of changes in computers, whatever you call it, social medias. Holistic reforms. of comprehensive reforms of IT Act 2000 is the need of the hour. Holistic reforms of section 66, of IT Act 2000 is the need of the hour. Right? So that is a broader way how, and just because that was a 2013 question, we are broadly, even if you write this question today also, how you should write. So we have tried to structure it in and around that. Right, so try to go through it once. Then again, kind of link to it. Look at it again. As I keep telling, in some questions, they will only directly give you subheadings, subparts. Look at it, 1. Clearly, subpart 1. Subpart 2. Subpart 3. So you don't have to generate subheadings here. Clearly, they are telling you, what do you understand by freedom of speech and expression? 19 clause 1. What do you understand means what? Sir, how should I define it? Recall your normal basics when you have studied for prelims basics also you would have understood. Freedom of speech and expression includes what all? Can you recall? Freedom of press. So what do you write? Freedom of silence. So right to information, right to criticize the government, right? All of that to an extent you have to explain. Then second part, does it cover hate speech also? Obviously no, so for that you have to write. Then why do you think films in India stand on it? Means in other words, why films are treated differently? Why do you think films are treated differently means what actually, what is the question? See, for newspapers you don't have a censorship. For electronic media you don't have a censorship. But obviously for that what you have? For films, not exactly censorship, you have CBFC, Central Board for Film Certification. Only after receiving the certificate you have to release that. That means what? You have to go through a process. Why is that is the question they are asking. Understood? So third aspect, you may not get the question because it doesn't get repeated so often, but I think you got the broader perspective. So whatever we have written there, more or less will overlap. So please write this question, because in the beginning, the more and more you write, obviously you will get a structure of that. Then when we read DPSP, because fundamental rights, as I told, is the most important part. Topic 1, fundamental rights is most important. Under that, which is most important? Freedom of speech and expression, compared to even that which one? Article 21. So whatever left out questions are there, we'll discuss that. That we'll put it under probable questions. So 3 subparts. So get hold on the arguments. So same arguments, use it, whichever question they ask in which one related to freedom of speech. Automatically, see, whatever words use, chilling effect on speech and expression, procedural safeguards, automatically wherever you write freedom of speech and expression question, just use that. It doesn't matter what is section 6. Link it to the demand of the question, that's it. Okay, so directly you can directly start with freedom of speech. Other than that, what you do is, broadly the topic is about what? Fundamental rights, basics. Fundamental rights mentioned in, especially in the beginning, even if the question is on panchayats, let us say, so like critically analyze the effectiveness of panchayats, it's a beginning what you have to write. Panchayats are mentioned in part 9 of the constitution, article 243 to 243O. It was introduced by 73rd amendment, and mandatorily it should be there. Fine. And article 40 reference to Gandhi Gram Swaraj idea, either in introduction or in conclusion, 100% you have to write. There is no way you cannot write about article 40 DPSP, Gandhian dream of Gram Swaraj, all these aspects. Same way, whenever possible, if the question is on fundamental rights, first write the basics. Fundamental rights mentioned, you know that, please write that. Mentioned in part 3, article 12 to article 35. Then shift to the keyword. Part 3 of the constitution, article 12 to article 35. And then where do you find this? First clarify that. Freedom of speech and expression is mentioned under, freedom of speech and expression is mentioned under right to freedom, article 19 to 22. Freedom of speech and expression is mentioned under Article 19 to 22. Is mentioned under right to freedom, which is 19 to 22. Fine. Yeah. Now, first part. What do you understand by that? Explain. 19 clause 1 subclause A includes multiple provisions based on Supreme Court's interpretation. 19 clause 1 subclause A includes multiple provisions based on Supreme Court's interpretation. So, as a list 4, 5 you write, and then there itself wherever possible you should write the cases. Like what? First one, the most important, freedom of press. Freedom of press. In bracket, Ramesh Thapar case. Again, substantiation part. ROMESH, Ramesh Thapar case. Of course, there are so many other cases also. You can write Brijbhushan case, all those things. Ramesh Thapar case, first one. Then, which one? Right to information. Right to information. PUCL case. There is also Indira Gandhi versus Rajnarayan case. PUCL case. Then right to silence. Remember the case? Which one? Jehovah Witnesses case. Bijo Emmanuel. Right to silence. Bijo Emmanuel case. BIJOE Emmanuel. Or famously called as Jehovah Witnesses. Anything. Jehovah Witnesses case. Fine, that is another one. Next one. Right to telecast. Right to telecast one's own views. One's own as well as others. Right to telecast one's as well as others' views. For this again, which is broadly linked to freedom of press itself. Right, then which one you can include? Internet also you can say. Right to information, right to criticize the government, right to protest. Okay, if you have that. Right to dissent, Bhima Koregaon case. Right to dissent, Bhima Koregaon. Bhima Koregaon case. KOREGAON. Bhima Koregaon case. Now that is your first component, because they are not asking you critically analyze. That part is what? What do you understand by freedom of speech and expression? Because obviously it's a very, very broader topic. Now comes your, does it cover hate speech also? Okay, even if you want that, what you can do for freedom of, what do you understand by, there is still what you can write. It is subjected to reasonable restrictions. Which one? 19 clause 1 subclause A, Article 19 clause 2. It is subjected to reasonable restrictions under 19 clause 2. And write those. You don't have to write all the 8, because in mains you don't have to mention everything. Under 19 clause 2, and then 4, 5 grounds you write. So recall what are the grounds? Sovereignty, integrity of India, security of state, friendly relations with foreign countries, sovereignty and integrity of India, security of India, security of the state, friendly relations with foreign countries, public order, morality, etc. You still have more, obviously, contempt of court, defamation, all of those things. So that is basic idea, your first subheading, first subpart. Now the second subpart. That itself you put the heading, as I keep telling, make use of the keywords in the question. Does it cover hate speech? Does it cover hate speech? Now first, what do you mean by that hate speech word? First clarify. The term hate speech is not defined in the Constitution, even actually in any law. The term hate speech is not defined, it's not even mentioned actually. The term hate speech is not defined in the Constitution. But how can you broadly say it? It can be defined as, it can be considered as, it is not defined in the Constitution, it can be considered as any kind of expression. The term is not defined in Constitution, it can be considered as any form of expression. It's saying hate means what? which deliberately tries to spread hatred, any kind of expression which deliberately tries to spread hatred against particular community, which deliberately tries to spread hatred against any particular community. To spread hatred against any particular community. Clear? So that is the basic idea. Now the point is what? Does it cover hate speech also? For that you have to write what? Clearly you can say that, but because they are asking you like a question, it does not means Article 19 clause 1 subclause A does not include. It does not include hate speech. It does not include hate speech. Because what does it violate then? Clarify that. It violates, as an argument, it violates public order, incitement to offence, incitement to offence. Hence, it is or based on reasonable restrictions, it is not allowed. It violates public order, incitement to offence. Hence, based on reasonable restrictions, it cannot be allowed. Based on reasonable restrictions, it cannot be allowed. Fine. If you stretch the argument, what you can say, it also leads to, hate speech also leads to communal riots, thereby affecting Article 21. It also leads to communal riots, thereby affecting Article 21, right to life and liberty. So, as I keep telling, whenever you have more content, irrespectively what you have to do, keep on structuring it as point format. Then, it is a criminal offence under IPC. It is a criminal offence under IPC. Then, Supreme Court in Pravasi Balai Sanghatan case. Supreme Court in Pravasi Balai Sanghatan case. Supreme Court in Pravasi Balai Sanghatan case said that hate speech is not a form of expression or cannot be allowed as a form of expression. Pravasi Balai Sanghatan case said that hate speech cannot be considered or allowed, any words, as a form of expression. So as I keep telling, please, whatever keywords you have to keep on underlining. So you just have to generate the points in and around it. Hate speech cannot be considered as a form of expression. Then Law Commission had drafted a bill. Law Commission had recommended a separate act. Law Commission had recommended a separate act to tackle hate speech. Vishwanathan Committee. Law Commission had recommended a separate act to tackle hate speech. Vishwanathan Committee also recommended stringent provision, means increase the punishment. Recommended stringent provision to penalize hate speech. Vishwanathan Committee recommended stringent provision to penalize hate speech. To penalize hate speech. Fine, okay, that is second broader point. Does it cover hate speech? Obviously no. For what reasons? What else are other arguments you can add? Supreme Court, Law Commission, all those things. Now the subpart is, third subpart is what? This you can't expect every time because it's not a theme. Maybe that year I think some movie related ban, something would have happened. That's why they had asked that question. But broadly, you can say that what? Why films are treated, not a very important subtopic, but because it's there in the question, I'm just generating it. Why films are treated differently? Why films are treated differently? First tell how is it treated differently, then we'll come to the reasons why. How is it treated differently? First tell. What you can say? Print media, electronic media. Print media, electronic media, what are they not? they are not subjected to print media, electronic media are not subjected to pre-censorship before release kind of a one. Print media, electronic media are not subjected to pre-censorship laws. However, obviously for movies, what do you have? With respect to film, Cinematograph Act. However, with respect to films, Cinematograph Act keyword. Cinematograph Act. Cinematograph Act and obviously which famous board? CBFC. Cinematograph Act and CBFC. CBFC is in charge of certification before release. You can't call it as censorship. He is responsible for certification. Central Board for Film Certification. Responsible for certification before release. So this is how is it different. Now the point what you have to write is what? Why only that is treated differently? That why part you have to write below. Understood? Yeah, why part first you write. Films have a broader reach. Films have a broader reach compared to other forms. Of course, now things are changing a lot. Films have a broader reach compared to other forms. Hence, that means what it may impact? Hence, it has an impact on common man. It has broader reach compared to other forms. Hence, it has a huge impact on the common man. Fine. 2. Second one. What you can tell? As it is a audiovisual format. As it is audiovisual format, it has greater strength in conveying the message. It has greater strength in conveying the message. Hence, it can build stereotypes. It has greater strength in conveying the message or greater reach in conveying the message. It can build stereotypes. So like whatever the cultural angle, all those things, it has a very strong impact on the cultural aspect. Right, that's another one. Next one. Next, what you can say? Yeah, it also has international reach. It also has an international reach, thereby an impact on the image, reputation of the country. It also has a broader reach, thereby an impact on reputation, image of the country. Thereby impact on the reputation of the country. Understood? Hence, based on reasonable restrictions under 19 clause 2, hence based on reasonable restrictions under 19 clause 2, it is based on reasonable restrictions under 19 clause 2, it is subjected to certifications. Subjected to certifications. Right? Obviously, but then what happens? Sometimes it gets misused. That angle you generate, just generating, making answer will stick. However, in various instances, CBFC has been criticized. However, in various instances, CBFC has been criticized for misusing its power. CBFC has been criticized for misusing its power and hurting speech and expression. 19 clause 1 subclause A. And hurting Article 19 clause 1 subclause A. There are various instances, you know, Vishwarupam case, Utta Punjab case, Padmavat case, Bandit Queen case, like that. So for that, what you have to do? To address this, Sham Benegal Committee recommendations. To address this, means to address this misuse. To address this, Sham Benegal Committee recommendations. That's the keyword again. Whenever you have CBFC issue, which again, as I am telling clearly, very less chance you have this film aspect getting repeated. Speech and expression, anytime you may have. To address this, Sham Benegal Committee recommendations should be implemented. Sham-Benegal committee recommendation should be implemented. I think that itself can broadly become conclusion. Sham-Benegal committee recommendation should be implemented. Clear? Yeah, that is your question on. So, 3 questions on speech and expression. Then you don't have any question on that. This is again another broader question. Look at it how they are asking. Again, that year some issue would have been there, which I regularly also you have that. Clearly subparts you have. Does the right to clean environment entail legal regulations on? Means because of right to clean environment, can we put restrictions on burning of crackers? That is your subpart 1 clearly. So you have to link between right to clean environment and this angle. 2 is what? Discuss in the light of Article 21 and judgments. Okay, they are saying link to this part. Link to Article 21 because obviously right to clean environment itself is what? MC Mehta case, morning we wrote whatever sustain all those angles. So that itself is related to 21. So for that they are bringing, and then broader question. Of course, you have to bring the cultural angle also, how it gets balanced, what if it goes beyond reach, what solutions you will suggest, all those things. This again, chances of repeating is not there because, or you never know because Diwali time and again it will be there. Understood? But you have to keep this in mind because Article 21 again repeat question. Now this one, discuss the positive. Okay, before this what we'll do, which angles we have to keep this in mind. In fundamental rights, okay, if in case in fundamental rights some other aspect you have to keep it in mind. Content part I am telling, answer writing part we'll do. So what points you have to keep that in mind? First one, because other aspects is fine, you leave it. What major cases? 25, this one. First one, under fundamental rights, content part, doctrine of essentiality. Doctrine of essentiality, because any time you may have to use the points. Essentiality, or also called as what? Essential practices. Doctrine of essentiality or essential practices, which is what? Shirur Mutt case 1954. Shirur Mutt case 1954. So content part it has to be there. Shirur Mutt case 1954. And obviously what is it related to? It is a judicial innovation. It is a judicial innovation by the Supreme Court. It is a judicial innovation by Supreme Court to determine the essential practices of a religion. To determine the essential practices of a religion. To determine the essential practice of religion. Fine. Obviously, what is it? Next point, it is nowhere mentioned in the Constitution. Keep writing in points. Broader by in and around that, if they ask a question, you should be able to easily handle it. It is nowhere mentioned in the Constitution. It is nowhere mentioned in the Constitution. Fine. So that is another point. Now, in which cases has it used it? Or what we'll do? Okay, cases also you can write, then we'll write the arguments for and against. First one, Venkata Ramana Devaru case. Venkata Ramana Devaru case. Venkata Ramana Devaru case. Restrictions to few sections. Restrictions on few sections to the entry of temple is not, in other words, untouchability angle. Restrictions to or on few sections with respect to entry to temple is not an essential practice. With respect to the entry of temple is not an essential practice. It is not an essential practice. Fine. So that is first angle. Then Shirur Mutt case obviously. Next angle is what? Sabrimala angle. All India Young Lawyers Association case. All India Young Lawyers Association case. Same, restricting women's entry into the temple is not an essential practice. Sabrimala case, restricting women's entry into the temple is not an essential practice. It is not an essential practice. Fine, then Shaira Bano, triple talaq. Shayara. Shaira Bano case, triple talaq is not an essential practice. Triple talaq is not an essential practice. Fine, any other case you recall under this? That is Karnataka related. Karnataka High Court has said that, but Supreme Court has still not clarified. Then Ratilal Gandhi case is there. That's when Ismail Faruqi is there. If you want, that also you're right. That's not a landmark one, but still. Ismail Faruqi case, famously Ayodhya case related. Ismail Faruqi case. Prayer is not an essential part. Sorry, prayer is an essential part. Prayer in a mosque is not an essential part. Namaz, that is prayer means here. Prayer, that is namaz, is an essential practice of Islam, but prayer within the mosque is not an essential practice. Prayer or namaz within the mosque, namaz is an essential practice, within the mosque is not an essential practice. So that is broadly the cases angle. Fine, you still have so many. Remember that Ananda Margi case, all those things are there, but that's fine. Now what you have to understand, if in case they extend this as a mains question, then what you have to generate? First is what? Significance of the doctrine. Do you think actually it is required? Significance of doctrine. Why do you think it is required? Significance of the doctrine. Significance of the doctrine. You tell me, do you think that our doctrine is required? If answer is yes, then why? Sir, I know it is required, but how to generate the points? That's the main challenge. The main challenge with means first one, freedom of religion is not absolute. 25. Freedom of religion is not absolute. Freedom of religion is not absolute. Hence, reasonable restrictions apply. So hence what is there, what is not there, they will clarify. Hence reasonable restrictions are required. Reasonable restrictions are required. Then, India being a diverse country, has multiple socio-cultural practices. India being a diverse country has multiple socio-cultural practices which goes against others' rights. Then ideally who has to determine all these things? Or Supreme, first you give the Supreme, okay. Ideally, legislature should determine. Ideally, legislature should determine the same essential practices. Legislature should determine the essential practices, but obviously what will happen? However, political pressure makes it complicated. Ideally, legislature should determine the essential practices, but the political pressure makes it complicated. Then the only option is what then? Supreme Court being the guarantor of fundamental rights. Supreme Court being the guarantor of fundamental rights and guardian of Constitution. Supreme Court being the guarantor of fundamental rights and guardian of the Constitution has to interfere to protect others' rights. Fine, that is why is it needed, and of course various judgments show that what actually what you can say, various judgments of Supreme Court. Various judgments of Supreme Court. Various judgments of Supreme Court have brought reforms in the religion. That whatever you have written above, various judgments of Supreme Court have brought reforms in religious reforms, have brought reforms in the religion. Right? That is, why is it needed? Significance. Obviously, the next part is what then? Is it not so easy? Criticisms. Obvious criticisms are what? First, it has no constitutional basis. It has no constitutional basis. So, it is nowhere mentioned in the constitution. It has no constitutional basis. Point number one. Point number two, there is no clarity. There is no clarity on the parameters to determine. There is no clarity on the parameters to determine an essential practice. No clarity on the parameters to determine an essential practice. Fine. If you want a little more clarification, mention multiple parameters like, what all parameters they use? Multiple parameters like reference to the holy text. Multiple parameters like reference to the holy text. Like whatever, Bibles, Qurans, Veda, Upanishads, whatever, reference to the holy text. Next is what? How old is the practice? How long has it been practiced? How old is the practice? Did the founder of the religion refer to it? Did the founder of the religion refer to it? Founder of the religion referred to it. Opinion of religious scholars. Opinion of religious scholars are considered. So we never know what exactly they do. Opinion of the religious scholars are considered. So multiple things, multiple parameters. Automatically extension of that point is what? The doctrine is subjective in nature. Means it depends ultimately on whom? The judge. The doctrine is subjective in nature. The doctrine is subjective in nature depending on the belief system or depending on the opinions of the judges. It is subjective in nature depending on the opinion of the judges. Depending on the opinion of judges. Fine. The next one, it has contributed to. It has contributed to. You have heard that word. Okay, this. What is it contributed to? Judicio-papism. That is, judiciary acting like a pope of the religion. It has contributed to judicio-papism. That is, judiciary acting like pope of the religion. Judiciary acting as the pope of the religion. Right? So that is the broader angles. Of course, another point is there. It has contributed or it has led to over interference of judicial overreach. It has led to over interference of judiciary in religious matters. It has led to over interference of judiciary in religious matters. Over interference of the judiciary in the religious matters. Right? Yeah. So then, what is the balance there? Clarify below. Despite various criticisms, the doctrine has. Despite various criticisms, the doctrine has helped the Supreme Court, helped the apex court The doctrine has helped the Supreme Court in upholding, in protecting. It has helped the Supreme Court in protecting fundamental rights of the citizens. In protecting the fundamental rights of these citizens. Fine, but what you have to keep it in mind, however, it should be realized that social reform or socio-religious reform, it should be realized that socio-religious reform is a difficult process compared to political, legal, economic reforms. Socio-religious reform is difficult, complicated compared to which one? Political or legal or economic reforms. Hence, a long-term approach should be taken. Hence, a long-term approach should be taken, and freedom of religion should not be affected. Means you should not over interfere. Long-term approach should be taken, and freedom of religion should not be affected, or should not be diluted a lot, any words. Because this question is also pending, maybe because it's a little kind of controversial angle, maybe for that reason they have not touched, or maybe in the constitution there is no clarity in that, multiple reasons. But whenever you still have a chance on mains question on doctrine of essentiality, because it's a landmark doctrine. Basic structure and constitutional morality, we'll write it together when we write amendment angle. But let's stick to fundamental rights angles first. So this should be there in your content part. Then what should be there? Okay, Aligarh Muslim University, okay, that's all not necessary. Article 29, Article 30 related minority, those are prelims angle you'll be knowing. Okay. Okay, few points related to minority institutions, because sometime 1 year, I think 1 or twice they have asked. I'll show you that question in, I think I would have put it under bodies. Rights of minorities, put the heading. Landmark cases, major observations, at least that should be there. What is basics we will anyhow have. Article 29, what is that? Article 30, what is it? That all you will have. Anyhow you can recall. Article 30 are rights of minorities. So what cases should be there? First one, as a list you write. First major case is what? Always when you write this, TMA Pi Foundation case, 11 judge bench. TMA Pi Foundation case. TMA Pi Foundation case. So what did Supreme Court say? Supreme Court said that Article 30 is not absolute. Supreme Court said that Article 30 is not absolute. It can be regulated by the, or minority institutions can be regulated by the state. Article 30 is not absolute. Minority institutions can be regulated by state. Minority institutions can be regulated by the state. Then they also had told another point, which is what? Minorities should be determined based on the population. Minorities should be determined based on the population within a state. So state should be the unit. Minorities should be determined based on population within a state. So that means state should be the unit of determination based on the population within a state. Right? That is first major case. Then second, which is broadly still related to the same one, which is what? Kerala Malankara Syrian Catholic Church case. Kerala Malankara, Malankara Catholic College case or Syrian Catholic College case. Kerala Malankara Syrian Catholic College case. Right, more or less same. Article 30 is not absolute. Article 30 is not absolute. Fine. Government can put restrictions on, government can put regulations on whatever. Government can put regulations on what all? Academic qualifications of teachers. Government can put regulations on the academic qualifications of teachers, admissions of students, entrance, academic qualifications of the teachers, admissions of students, fee structure, syllabus, examinations, etc. Then what do they have? Minority institutions can determine their own governing boards. Minority institutions can determine their own governing boards and manage their own property. Determine their own governing boards and manage their own property. And manage their own property. Right? So those are important angles here. Then, because it is again in news, if you have seen, I think February, March, Supreme Court was looking into this issue again, Aligarh Muslim University issue. Aligarh Muslim University issue. Aligarh Muslim University issue. Just briefly, I'll sum up. If in case they ask, you should be able to generate points. Aligarh Muslim University issue. So he tried the historical angle. First established as Anglo-Mohammedan. First established as Anglo-Mohammedan College. I think Oriental College also they tell. Anglo-Mohammedan College by whom obviously? Sir Syed Ahmad Khan. Anglo-Mohammedan College by Syed Ahmad Khan. Sir Syed Ahmad Khan. Anglo-Mohammedan College by Sir Syed Ahmad Khan. Then in 1920, Aligarh Muslim University Act was passed. So British time itself. In 1920, AMU, Aligarh Muslim University Act was passed. Aligarh Muslim University Act was passed. But what did they not clarify? It was not mentioned as a minority institution. So they did not mention that it's a minority institution. It was not mentioned as minority institution. It was not mentioned as a minority institution. Then Aziz Basha case. AZEEZ. Aziz Basha. Aziz Basha case. Supreme Court said that AMU is not a minority institution. Supreme Court said that AMU is not a minority institution. AMU is not a minority institution. Then Parliament amended the Act in 1980s. Parliament amended the Act in 1980s. In 1980s and mentioned it as minority institution. And mentioned it as a minority institution. And mentioned it as a minority institution. Then Allahabad High Court. Allahabad High Court reiterated, which one again? Aziz Basha case. Means again told, no, it's not minority institution. Allahabad High Court reiterated Aziz Basha case. Aziz Basha judgment. Reiterated Aziz Basha judgment. Right. So then now what is the statement? At present, Supreme Court is re-looking the issue. Re-looking into the issue. And at present, what is it? And it is considered as a minority institution. So as of today, we have to see based on judgment. At present, it is relooking into the issue and it is considered as a minority institution under Article 30. It is considered as minority institution under 30. Right, so this is the broader angle about Article 30 angle. 29, you don't have any cases there. I mean, any major mains chances are relatively less. 28 is also relatively less. 23, 24. Okay, those are all basic points that anyhow you'll have child protection, labor prohibition, bonded labor prohibition, all those things you'll be knowing. 15, 16. 16 you may have chances. I think that reservation, okay, that I think I have framed few questions, EWS reservation, all those things. At that time I'll tell you 16 angle. Understood? Because normally if you have observed, there is another tendency of, which is all based on observations we can tell. If prelims questions you are there and which has become a little in news or some, that kind of question they repeat next year, I mean in the mains also. For example, if due process of law wasn't a discussion, something related to Article 21 you may expect in mains. Not 100% always, chances. So this year if you can recall Northeast Council, I think after a long time they have asked about Northeast Council or Zonal Council in prelims. So maybe on that angle if you take a extrapolation of that, you can expect a question on interstate council or zonal council. Maybe, nobody can be sure, that you can extrapolate. But then there is a question on which one, okay, parts you leave it. What else you had? Last year actually we were expecting a question, remember the due process of law in essence means that as, actually I was expecting a question, principle of natural justice itself. Because that was the answer also they had given. But UPSC did not ask about natural justice, they asked in general about Article 21. And there are few other also, I have already framed the question. Based on prelims, extrapolating and 2-3 questions. So if at least one if you get also, you can manage it better. That all we do. So anyhow, it's a very detailed one. Okay, so that's another point. Then 32, just at least sum up, because 32 on that also they have asked. Just sum up quickly. Ritz angle, because anyhow you would have mentioned it. Broader statements, that's it. Article 32, first point as a point, basic points, part of basic structure. Part of basic structure. Again, if you have forgotten that point, also clarify. Remember, not all fundamental rights are basic structure. Only fundamental rights like what? 13, 14, 19, 29, 32 are basic structure. If you have forgotten that, clarify that also. Just by somewhere in margin. Not all FR is part of basic structure. Only 13, 14, 15. Not all fundamental rights are part of basic structure. Only 13, 14, 15, 19, 21, 32 is basic structure. 13, 14, 15, 19, 21, 32 is basic structure. Right, so obviously 32 is basic structure, and you know that famous one, Ambedkar described it as what? Heart and soul of the constitution. The most important article, so many things. Because if they ask a basic question, because that tendency also UPSC has, like how they asked right to movement and residence. So write a note on Article 32 if they ask also, basic parts you should be ready, because that's a landmark article. Heart and soul of the constitution. Then 32 is only for whom? 32 is for enforcement of FR by Supreme Court. 32 is for the enforcement of fundamental rights by Supreme Court. Enforcement of fundamental rights by the Supreme Court. Then 226 provides a similar power for High Courts. 226 provides similar power for High Courts. Fine. Just to clarify, obviously what is it? It is borrowed from, writs is borrowed from UK. Very basics. This is the basic part, not the current affairs part. It is borrowed from UK. That's another one. And then remember that basic differences, you can fill that. Remember that very well. 32, 226 basic differences, that where can you, Supreme Court issue is throughout the territory, states can only, High Courts only within its territory, Supreme Court only for fundamental rights, High Courts not only for fundamental rights but other, for High Court it's an option, for Supreme Court it's an obligation, hence all of that you keep it in mind, because that basic, this is a basic question. If they ask, you should be ready to tackle that, which mostly normally also you will do, but I am just cautioning you should be ready for that. And so that basic difference. Then types of writ, just mention, you will be knowing the points. types of writs and then mention those 5 writs. Will not get into other details because that all you will easily understand. That's all prelims part. I will not get into deep into it. Types of writs. Just mention all those 5. Habeas corpus, mandamus, prohibition, certiorari, quo warranto. Nothing extra is needed there. Habeas corpus, mandamus, prohibition, certiorari, quo warranto. So, in whatever some 2-3 points, if in case they ask, you should be able to at least generate the points. Then, which articles again you have to keep it in mind because you never know, you may get always a question on that. 31A, Article 31 capital A, because there one in and around that you have a chance. 31 capital A added by which one? First CA 1951. Added by first constitutional amendment 1951. Fine, and what does it? What does it say? Laws passed by or acts passed by Parliament and state legislature. Laws passed by the Parliament and state legislature. Laws passed by Parliament and state legislature on specific subjects. On specific subjects cannot be questioned in court. On specific subjects cannot be questioned in courts even if it violates 1419. Cannot be questioned in courts even if it violates Article 1419. Article 14 and 19. Now, what are those specific subjects? Subjects include, because this mains question is still pending on right to property. Subjects include A, first one, amalgamation of corporations, merger, amalgamation of corporations. B, taking over the management of properties by the state. Taking over management of properties by state. Amalgamation of corporation, taking over the management of corporations by state. 2, 3, estates and its related rights. Acquisition of estates also you can write. Estates means that jagirs, inams, acquisition of estates and related rights. Acquisition of the estates and the related rights. Then D, modification or extinguishment. Modification or extinguishment of mining leases. Mining leases or rights of shareholders of companies. Modification or extinguishment of the mining leases or rights of shareholders of company. Rights of the shareholder. That one you have to keep this in mind, 31A. So both can pass the laws, not necessarily Parliament or state legislature. Of course, there is a check if it's state law, it should get the all this. That's all not necessary. That's all prelims angle. So because who will give the permission? That all is prelims angle. Mains angle, what is it? Another most important article is what? Because once they have already asked this question, I think that we have put it under judiciary 9th schedule 31B. Next one is Article 31B 9th schedule. Again added by First Amendment 1951. 31B 9th schedule added by First Amendment 1951. Fine. And what does the wording say here? Any law passed by Parliament or state legislature. Any law passed by Parliament or state legislature can be protected from judicial review. Any law passed by the Parliament or state legislature can be protected from judicial review. Can be protected from judicial review if it is added to 9th schedule. If it is added to 9th schedule, even if it violates any fundamental right. can, if it is added to 9th schedule, even if it violates any fundamental right. So it is any law on any subject, even if it violates any fundamental right. That's why, as we keep telling, 31B is greater than 31A. Scope of 31B, you just write in direct one, hence 31B greater than 31A. 31B greater than 31A. Then, obviously, with respect to this, the landmark judgment is what? IR Kohlo versus State of Tamil Nadu. COELHO. IR Kohlo versus State of Tamil Nadu. IR Kohlo versus State of Tamil Nadu. So, what did Supreme Court say in this case? Obviously, what is the check they put? Even if an act is added to 9th schedule, even if an act is added to 9th schedule, it can still be subjected to judicial review. Even if an act is added to 9th schedule, it can still be subjected to judicial review. Fine, that is the core point. But why is it? Because the reason is judicial review, JR is part of basic structure. Judicial review part of basic structure. That is second point. Next extension is what? Only those acts added, obviously which date? After 24th April 1973, subjected to judicial review. Only those acts added after 24th April 1973. Only those acts which are added after 24th April 1973 is subjected to judicial review. It is subjected to judicial review. Right? Then again what they gave? Dual test. Like how you had triple test in case Pudaswamy, this is dual test. Dual test. Dual test. First one A. Does the act violate a fundamental right? Does the act violate a fundamental right? B. Next question is what? Is that fundamental right part of basic structure? Does the act violate a fundamental right? Is that fundamental right part of basic structure? Means is it 13, 14, those angles? That means what? If it is yes, the answer is what? Then that means what? If it is yes, the act is declared unconstitutional. If yes, the act is declared unconstitutional. If yes, the act is declared unconstitutional. Right? So this is of course related to basics because questions is pending on these things. That's why we wrote it. You may anytime get a chance on that. That's a fundamental related rights. I mean fundamental rights related PYQs. Now, what aspect should be there in your before preamble? This one. Because of this, you recall even in your normal class also, because of, but maybe if you might be not from OGP also, but still on UCC regularly we write. Again, it is under news because of the Uttarakhand issue, all those things. Fine. So before that, on DPSP, very rare questions for mains angle because on that larger topic they can ask one question every year. See, on entire one I am telling which one? Preamble, FR, fundamental DPSP, duties, amendment of constitution, basic structure, constitutional morality, all of that combinedly plus cases related to that, they can ask one question because there are so many other topics. Hence, priority always goes to fundamental rights, which broadly we have covered. Some current affairs angle is there, as I told, right to same-sex marriage, all those things, we'll do that. First, let's write before this, on DPSP, what content should be there in your notes. First, basic content you write, which is more or less obviously overlap with your basics itself, but only mains part. I am not getting into prelims angle, but DPSP. What statement you can use, all those things. Ambedkar, because these statements you can always use in your answer. I'll show you how we can use that. Ambedkar called it as what? Novel features of the constitution. Novel features of constitution. Granville Austin. Granville Austin. FR plus DPSP equals conscience of constitution. FR plus DPSP equals conscience of constitution. Conscience of constitution. Then MC Chagla, former Chief Justice of India. MC Chagla, Chagla. MC Chagla. If DPSPs are truly implemented, India will be a heaven on earth. MC Chagla. If DPSPs are truly implemented, India will be heaven on earth. So these statements and all, see, even during basics we do, but here cautiously what you have to keep using, these statements you have to use in your introduction or arguments or conclusion part. That this is also a substantiation part. When you write that, as said by former Chief Justice of India MC Chagla, so implementation of DPSP in true spirit makes India heaven on earth. That means what? Your substantiation, 0.5 marks extra. Fine. Yeah, another one, MC Setalwad, first Law Commission chairperson of one of the Attorney General of India also, former AGI. MC Setalwad, former AGI, Attorney General of India. DPSPs are beacons of light to the court, means they will guide the courts, of course to the state also. DPSPs are beacons of light, BEACON, beacons of lights to the court. Right. If you bring another case, Minerva Mills case, recall obviously Doctrine of Harmony. Minerva Mills case, Doctrine of Harmony. Doctrine of Harmony. FR and DPSPs are two wheels of the same cart. Doctrine of harmony or balance, whatever. Doctrine of harmonious construction is different. This is doctrine of harmony. DPS, fundamental rights and DPSP are two wheels of the same cart. Right? So these statements will be substantiation part. Then what are the characteristics, all those things you know, very basics one recall. So it is inspired from instrument of instruction, those are all basics, that all you will be mostly knowing. DPSPs are non-justiciable, keyword that you have to keep it in mind. Most importantly, which DPSPs you have to keep it in mind, because regularly you may have to use these DPSPs in answers. All the DPSP is not necessary, it is not required also. Under Socialist, which one? Under Gandhian, which one? Under Liberal Intellectual, which you have to keep it in mind by heart, because you have to use them in mains. Under Socialist. Socialist DPSP. 38. Minimize inequalities of. They secure social justice also, that's not necessary. What you should recall, that I will only tell. Minimize inequalities of income, opportunities, facilities. Minimize inequalities of income, facilities and opportunities. Minimize the inequalities of income, opportunities and facilities. Then 39 clause B, you should keep this in mind. 39 clause B, use resources for common good of all. Use resources for common good of all. Clause C, prevent concentration of income and resources in few hands. Prevent concentration of income or wealth, whatever. Concentration of income and resources in few hands. Prevent concentration of income and resources in few hands. Clause C. Clause D, clause E, all those things not necessary. Directly 39 capital A. Remember last year question also. 39 capital A. Not directly related to that. Free legal aid to the poor. Provide free legal aid. Free legal aid to the poor. Free legal aid to the poor. Then 41, 42, all those things not important. Maternity relief, 43, capital A, 47, because if there is a question on health. 47, improve public health and nutrition. 47, improve public health and nutrition. Improve public health and nutrition. That is under Socialist. Then under Gandhian, what you should keep it in mind? Gandhian, of course, important. Poverty. Article 40, organize panchayats and give them adequate powers. Or organize panchayats and make them units of self-governance directly. Article 40, organize panchayats, give them powers to make them self-governance, units of self-governance. Organize panchayats, give them adequate powers to make them units of self-governance. Then, whenever reservation, any issue is there, 46, promote educational economic interest of SC, ST and weaker sections. 46, promote educational and economic opportunities. Educational and economic opportunities of SC, ST and other weaker sections. Intoxicating drugs, drinks, all not necessary. I think it's fine. That's I mean, there's still more, but that is more than enough. Khaap Panchayats, everything you have. Okay, cooperative angle. If you want, you can write that. Cooperative angle. 43. 43. Khadi cottage industries. Promote Khadi cottage industries. And that itself, another one is what? Promote cooperatives. Promote cooperatives. Right? Then under liberal intellectual, what do you have to keep it in mind? Liberal intellectual. Liberal intellectual. 44 obviously UCC. 44 UCC. Fine. 48 agriculture, animal husbandry on scientific lines. If there is a question on any of these things, agriculture, animal husbandry on scientific lines. 48. 48 capital A, protect environment, forest. 48 capital A, protect environment, forest. 50 SOP, protect environment and forest. Article 50 SOP, separation, you know that. 51 obviously is what? Yes, peaceful international relations. Whatever you have, so many words, abide by international law, so resolve disputes through arbitration, promote healthy cooperation between multiple, whatever, all those things, basically peaceful international relations. Then that's it for that. Then what DPSP is added, all those are all prelims angle, not necessary for us. Directly, if in case they ask that, just sum up in quick ones. Conflict between FR and DPSP. Conflict between FR and DPSP. Very quickly, we will not write in sentence. First is obviously what? Champakam Dorairajan case. FR greater than DPSP, that's it. Champakam Dorairajan case, FR greater than DPSP. But what they told, however, FR can be amended. FR greater than DPSP, but FR can be amended. Then Golaknath case. Fundamental rights sacrosanct, hence cannot be amended. Fundamental rights are sacrosanct, hence cannot be amended. Fine. Then Keshwananda Bharti case, 3 points. FR greater than DPSP, FR greater than DPSP. 2, it can be, FR can be amended. FR greater than DPSP, FR can be amended. 3 is what? Don't violate basic structure. Then Minerva Mills, I have already told, don't violate basic structure. And I don't have to write Minerva Mills again. So that is the basic points that you have to keep it in mind. Prelims angle, all those things, will not get into that. So different, all those things, because so many times you would have studied. Which one Now the point is only question that has been asked, because few other questions are pending. Like for example, as I told, if they ask a question on trace the evolution of conflict between FR and DPSP, you have to do this. If they ask a question on, let's say for example, which one difference, okay, that they can't ask. Maybe do you think FR and DPSP balance is required to realize the goals of constitution? Something like that, they may try to make a broader question also. So any which way you should be able to generate the points. I'll show you a few questions are there. Before that, very famous question, n number of times you have written, but it's always expected UCC. It should always be there. I think mostly you'll be knowing by now. Try to recall what all UCC related points are there. Means question, very important one. You can write for this also or in general also. UCC. Fine. Yeah, first clarify. Civil aspects, and then under that, subdivide two. First one, non-personal aspects, civil related provisions, non-personal aspects, like what? Example, contracts, agreements, uniformity already exists. Uniformity already exists. Example, CPC, Indian Contract Act. So under civil aspects, non-personal aspects, not related to the marriage, family angle, contracts, agreements, companies, all those things, you already have uniformity. It's the same law for all. Example, Contract Act, CPC, Civil Procedure Code, etc. Then, which are non-personal, personal aspects. Personal aspects, that's what is your marriage, divorce, property succession, etc. Marriage, divorce, property succession, etc. Uniformity does not exist. Uniformity does not exist. For Hindus, Jains, Buddhist, Sikh, Hindu code bill exists. For Hindus, Jains and Buddhists, Hindu code bill exists. That means what? For Muslims, Christians and Parsis, their own religion-based personal law exists. For Muslims, Christians and Parsis, religion-based personal law exists. Religion-based personal law exists. Right? Then criminal aspects. Law, crime related. Criminal aspects, uniformity already exists. Criminal aspects, uniformity already exists. Obviously what? Three, whenever you write that, Evidence Act, CRPC, of course now you can rename it also. I think from July 1st they have told that it will come into force or something. Evidence Act, CRPC, IPC. If you want the new names, you write the renames also. For CRPC you have to write it as what? Bharatiya Nagarik Suraksha Sanhita, BNNS, BNSS, sorry. CRPC in bracket BNSS from now on, from future. For Evidence Act, Bharatiya Saksha Samhita, BSS. For IPC, Nyaya, BNS. So criminal aspects, already uniformity is there. Non-personal civil aspects, already uniformity is there. So the only issue is about what then? Personal civil aspects. That is where the question is about. Understood? Now, below that clarify. Sir B.N. Rao committee. Sir B.N. Rao committee recommended codification of Hindu personal law. This is British era. Sir B.N. Rao committee recommended codification of Hindu personal law. Or you can say during British era, pre-independence. Codification of Hindu personal law in the British era or in the pre-independence era. Then, because a bigger picture, it's a very famous question, UCC one. Again, if they ask it also, it's a very direct question. It will become a category A only. To Ambedkar drafted Hindu Code Bill. Ambedkar drafted Hindu Code Bill which was rejected or which was opposed. Ambedkar drafted Hindu Code Bill which was opposed. Entire picture I am giving. Hence what happened later? It was subdivided into, and then write those 4. Actually 5. It was subdivided into A. Hindu Marriage Act. Subdivided into Hindu Marriage Act. B. Hindu Succession, property related. Hindu Marriage Act, Hindu Succession Act, Hindu Guardianship Act, Hindu Guardianship Act, then Hindu Maintenance Act, then Special Marriage Act. Maintenance Act and then Special Marriage Act. Right, that is the basics one. Now, arguments in favor of UCC. Why do you need it? Arguments in favor of UCC. Whatever you have written, that all you can't write in exams, but for conceptual clarity, you should have it. Arguments in favor of UCC. First, tell what is the basic definition of UCC. UCC refers to application of the same law. UCC refers to the application of same law with respect to the personal aspects of civil law. Application of the same law with respect to the personal aspects of civil law, irrespective of the religion. Irrespective of the religion. That is the basic definition. Now, why do you need it? First one, it upholds secularism. It upholds secularism. How? By keeping religion out of. It upholds secularism by keeping the religion out of legal aspect. Uphold secularism by keeping religion out of legal aspect. Keep the religion out of legal aspect. B. Upholds unity and integrity of the country. Enhances unity and integrity of the country. Upholds unity and integrity of the country by applying same law to all. By applying the same law to all. Applying same law to all. 3. Protects rights of vulnerable sections, especially women. Protects the rights of vulnerable sections, especially women. And of course, extension of that same itself we can write, especially the rights of women, and thereby brings religious reforms. Thereby bringing religious reforms. Thereby bringing religious reforms. And that's another one. Next, Ambedkar, Nehru, Vajpayee, Kalam have supported it. Ambedkar, Nehru, Kalam, Vajpayee have supported it. Have supported it. Then Supreme Court in Shabano case. Supreme Court in Shabano case. Shaira Bano case. Shabano case, Shaira Bano case, Sarala Mudgal case, Daniel Latif. So many are there, you write 1 or 2, it's fine. Shabano, Shaira Bano and Sarala Mudgal case has supported it. Has supported it. Right, these are all various reasons why obviously it is needed. Of course, it is based on equality angle also. And if you want, link to that Article 14 also. UCC upholds Article 14, equality before law. Just write equal. You know that UCC also upholds or favors Article 14. Now comes here challenges in implementing UCC. Challenges, not criticism, actually challenges. Challenges in implementing UCC. First one, freedom of religion, Article 25. Freedom of religion, Article 25, and rights of minorities, Article 29. Freedom of religion and rights of minorities may be affected. That depends on the content, but the criticism part you have to write. Rights of minorities may be affected. A. Rights of minorities may be affected. Then, obviously, who's one? Scheduled tribes have special provisions. STs, scheduled tribes have special provisions under Article 371. Under Article 371 and Schedule 5 and 6. 5th and 6th schedule with respect to the cultural aspects. Provisions of 5th and 6th schedule with respect to cultural aspects. Right, that's another challenge kind of a one. Then Law Commission did not support, or Law Commission said that UCC is neither necessary nor desirable. Law Commission said that UCC is neither necessary nor desirable. It is neither necessary nor desirable. Then next one is what? Apprehension of means fear. Apprehension of imposition of majoritarian values on minorities. Apprehension of the imposition of majoritarian values on minorities. Majoritarian values on minorities. That's another kind of a concern, challenge, whatever you call it as. Majoritarian values on the minorities. Right? Okay, that is broadly. So then how will you balance all these things way forward? Okay, another argument that you can use above is what? For that concern, DPSP is non-justiciable, hence what? Not mandatory to be implemented. Other challenge, concern, whatever, above. DPSP is non-justiciable, hence not mandatory to be implemented. Hence not mandatory to be implemented. Not mandatory to be implemented. So then how do you balance it then, way forward? Then we'll go to the broader conclusion. Way forward. First one, multi-stakeholder consultation. Multi-stakeholder consultation to build a consensus. Multi-stakeholder consultation to build a consensus. To build a consensus. A. B. Second one, codification of this Muslim, Christian and Parsi laws by the parliament itself. So let's not make it one separate for other communities. Codification of the minorities related Muslims, Christians and Parsi personal law by parliament itself, like Hindu code bill. So you don't have to make same for everybody, but let it be codified by whom? By parliament, like the Hindu code bill. Like the Hindu code bill. And what it should be based on? It should be based on constitutional values like gender justice, equality. It should be based on constitutional values like gender justice and equality. Based on constitutional values like gender justice and equality. That is true. Then in the long run, in the long term, UCC is necessary. You should always say you need UCC, no doubt about it. In the long run, UCC is necessary. UCC is necessary. Right, then now broadly how do you conclude it then? broader conclusion. Constitution makers wanted UCC to be enforced. Constitution makers wanted UCC to be enforced to uphold secularism and protect women's rights. To uphold secularism and protect women's rights. Hence, what we need to do? Hence, political parties should keep their interests aside. They should keep their interests aside and get together to realize the vision of Constitution. They should keep their interests aside and get together to realize the vision of the Constitution, goal of the Constitution. And get together to realize the goal of Constitution. Fine. On UCC, this is the only angle which is left out. I mean, the question, DPSP question, or else they should ask broader one. Two to three angles are there that I have made it as a probable question. That will come to that. First, let's finish off PYQ part. First is conceptual angle, then PYQ, then we have to go to the probable question angle. On duties, there is no single question also which has been asked on in mains. Not a single question. If in case they ask also, which is a very simple, remember that major for duties, if you keep this in mind, more or less you can manage. Rest all, I don't think major cases is there, nothing is there. If in case they ask significance of duties, remember all those things, why is it needed, what are the criticisms, that also if you keep it in mind, it is more than enough. Quickly, what should be there for the content part duties, just finish this off. Fundamental duties. Again, this is mostly related to your basics only. So, because there is no mains question angle asked, it is not important also from mains perspective. Just as a, you can say, precautionary principle. If in case they ask, what should be, how do you manage? First, the Constitution angle, Part 4A, 42nd Amendment 1976. Part 4, capital A, 42nd Amendment 1976. 42nd Amendment 1976. Of course, which country? USSR Swaran Singh Committee. USSR Swaran Singh Committee. That's it. Then list of fundamental duties. Only keywords you keep this in mind. Nobody will ask you the list. If just to manage your answer, you should keep few in mind. List of fundamental duties. First, abide by Constitution. Only keywords I will tell. You don't have to recall everything. Abide by Constitution. Respect national symbols. Abide by Constitution. Respect national symbols. Fine. If you want, you keep the Act in mind. I read the Act. Prevention of Insults to National Honors Act 1971. Prevention of Insults to National Honors Act 1971. So, because you never know, they may ask a question saying that how legislature has tried to implement fundamental duties through various legislations. If they ask, at least you should be able to manage. For that aspect, I am telling Prevention of Insults to National Honors Act 1971. Fine. B, second one, uphold, which is very generalistic, uphold India's second duty, uphold India's sovereignty, unity, integrity. Uphold sovereignty, unity, integrity of India. Uphold the sovereignty, unity and integrity of India. If you want acts, NSA, National Security Act, UAPA, that you know obviously. NSA, UAPA. C. Cherish values that inspired freedom struggle. Cherish values that inspired freedom struggle. There is no act, just keep this in mind. Cherish values that inspired freedom struggle. That inspired freedom struggle. So, this is if they ask a basic question, how to manage it. Fine. Then D is what? Be ready to provide national service. Be ready to provide national service. Be ready to provide national service. Then promote harmony, brotherhood. Promote harmony, brotherhood. For that you have obviously acts. Promote harmony and brotherhood. Acts, obviously what? Provisions of IPC. Negatively they tell, if in case you violate it, so punishments. Provisions of IPC. Right? Other angle of it is what? Renounce practices derogatory to women. Renounce practices derogatory to women. Practices derogatory to women. Obviously of the act, which is what? Prevent, directly you can write Indecent Representation of Women Act. Indecent Representation of Women Act. Indecent Representation of Women Act. Right. Then next one, which is what? Preserve composite culture of India. Preserve India's composite culture. Example: Ancient Monuments Act. Protect India's or conserve India's composite culture. Ancient Monuments Act. Then protect environment, forest. You have the acts. Next fundamental right, fundamental duty, protect environment, forests. So what are the acts? WPA, EPA, FCA. WPA, EPA, FCA. Then protect public property. Protect public property. Of course, you have Act, Prevention of Damages to Public Properties Act. Protect public property, Prevention of Damages to Public Property Act. Prevention of Damages to Public Property Act. Then promote scientific thinking, enquiry. Promote scientific thinking, enquiry. Promote scientific thinking, enquiry. Example, acts, prevention or prohibition of superstitious act, superstitious activities act. Not at the national level, state levels. Prohibition of superstitious activities act. Prohibition of superstitious activities act. Then next one is what? Strive towards excellence. There is no act, nothing, just write the general statement. Strive towards excellence. Then 86th Amendment 2002. 86th Amendment 2002, which is what? Duty of the parents to provide primary education, 6 to 14. Duty of parents to provide primary education. Duty of parents to provide primary education. Right? That list you have to keep this in mind. They are still not asked. Only if they ask, at least it will come handy for you. Then maybe what is this? What do you call it? Remember significance, 2-3 points. Keep that in mind. Like all, why is it necessary? And then criticisms, 2-3 points. If you remember that, that's more than enough. If you want, that also finish off. It's there in your books also, but just to be there in your notes. What are the significance? Why do you think FD is needed? Fundamental rights, significance. Just as a mind map, you write significance of fundamental duties, 4-5 keywords. Significance of fundamental duties. First one, promotes discipline, or to promote discipline in citizens. Promotes discipline in the citizens. Discourages anti-social, anti-national activity. Discourages anti-social, anti-national activity. Anti-social, anti-national activity. Fine. See, FR and FD equally important. FR plus FD equally important. for plus FD equally important. Fine. Then next one. Legislatures have implemented it through various acts. Legislatures have implemented it through various acts. That means that itself shows legislatures have implemented it through various acts. Then Justice J.S. Verma Committee, Justice J.S. Verma Committee recommended it to be continued. Justice J.S. Verma Committee recommended it to be continued. So let it continue. Recommended it to be continued. Then what are the loopholes then? Criticisms. Non-justiciable. Criticism, non-justiciable. Non-justiciable. B. Important FDs are missing. Important fundamental duties are missing. Like what? Like voting, taxes. These are all very basics one. There is no extra. But critical analysis angle is all in probable question we'll discuss. Like voting, taxes. Fine. The next one. Vague words used in FD. Vague words like scientific temper, reforms, composite culture. Vague words used in FD. Hence, misinterpretation. Vague words are used in FD, hence misinterpretation. Then, no major democracy has FDs of citizens. No major US, UK, you live it anyhow, they don't have written constitution, or France or Germany. No major democracy has FDs of citizens. Fundamental duties of citizens. Then, original constitution did not mention. In other words, Ambedkar did not want it, or Nehru did not want it, or Patel did not want it. Original constitution did not mention it. Fine. So that angles, if you can recall, most of it, under significance, you can add another point. Most of it is part of Indian culture. Most of them part of Indian culture. It's like codification of the traditional Indian values. Most of it part of Indian culture. So in and around that, if they ask, you should be able to generate the points. That's it. Understood? So then you still have questions on what? Basic structure, constitutional morality, all those things. Khaap Panchayats, okay, leave it. That's not a theme. This one, your constitutional morality is there. Basic structure is there. This also in a way basic structure related. Or that small states is there. You leave it. This is next topic. And then few probable questions are there. We'll do it. Just give me some 5-10 minutes break. We'll come back quickly. Okay, look at this. Please tell me, how can you structure this question? Pretty direct. The first part is clearly telling each adjective. That means obviously you have four keywords. So they are asking you discuss each adjective, and then the next part they are asking, are they defendable? So what should be the structure? Structure is very simple. For each keyword, divide it into three. One is what? First you define, tell what do you mean by sovereign. Then you tell positive examples. Then you tell the examples. Then you tell the criticism. So this is the structure. Same structure you follow for each and every keyword. That's your answer. Discuss each adjective, and again, even as I told you in the morning also, do not worry too much about the directive. Like for example, even if they ask explain, analyze, comment, critically comment, this, that, illustrate everything, more or less the structure of the answer will remain the same. You have to make it as holistic as possible. Only if they say comment, then what you have to do, write your opinion. Or if they ask, do you think, remember in someone's, do you think, what is your opinion? Then tell clearly what is your opinion, underline that, let it be clearly visible to evaluator. Or else in general you take it as what? Structure of the answer will more or less remain the same, no drastic changes. Though by literally the meanings will vary, what is explained, what is analyzed, practically it doesn't matter much. Because answers have become like that, content has increased a lot. So unless they specifically justify your opinion, do you think what is this so and so, or else more or less take it as same. Clear? This should be the structure. Like for example, just to structure it, because preamble wise they have still not asked, just to understand the structure, please write the question. Because let's say most of it, either they'll write this and this, they'll leave out on this. And they're clearly asking you this part. Most of students, they may not address it. All of that is a challenge. Understood? It will give you, if it's a 10 marker, 3.5 to 4. If you write only define and example, you leave out criticism, you leave out other defendable, 3.5, 4. You cannot get that 4.55. Clear? So how do you structure? First write basics. How do you, because the question is about preamble, you can define it exactly, but you can tell the context. Preamble is described as identity card of the Constitution by Preamble is defined as identity card of the Constitution by Palkhiwala. Identity card of the Constitution by Palkhiwala. Right? It is inspired from US. It is inspired, basics of preamble you are writing, it is inspired from US. It mentions the nature of Indian state. It mentions the nature of Indian state, goals of Constitution, nature of Indian state, goals of Constitution, date of adoption, and source of the Constitution. So you are just writing, remember basics you would have studied obviously for your prelims also, all this. Date of adoption, source of the Constitution. Basics. Now what you do, just for the subheading, adjectives mentioned to the word republic, right? That itself you can use it as a subheading. Adjectives attached to the word republic. So keywords of the question, regularly you have to repeat. That's the trick. Adjectives attached to the word republic. Fine. Under that, first, that structure you have to follow now. Sovereign. Now, what do you mean by sovereign? Basic definition. It means India is free from any kind of external control. It means India is free from any kind of external control. Any kind of external control. Fine. India became sovereign on Jan 26th, 1950. India became sovereign on Jan 26th, 1950. Jan 26th, 1950. That's the basic angle. Now, it includes both internal and external sovereignty. Means to determine your internal issues, external issues. It includes both internal and external sovereignty. Now, that's your definition, basic part you have written. The second component, what you have to write? Example. For example, India, which even in basics we write. For example, India rejected to join BRI or RCEP. India rejected to join BRI, Belt and Road Initiative, and RCEP. BRI and RCEP, obviously for what? For security, whatever, India's interest, based on India's interest, or for security reasons. For security reasons. That's a positive example. But what is the counter you have to write? However, being a developing country, what happens? There are challenges to India's sovereignty. There are challenges to India's sovereignty because of neo-imperialism and control by international organizations. Because of neo-imperialism and control by the international organizations. If you want example, India's agriculture and business, you can say investment related policies are based on the pressure of WTO. India's agriculture and investment related policies, is based on pressure of WTO. Is based on the pressure of WTO. Fine, that is first keyword, definition, example, criticism, angle. Then socialist. Basic definition first. Socialist. Fine, as a definition, if you want to write, what do you have to write it then? It is a economic system in which, political economic system also you can say, it is an economic system in which ownership of the resources, manufacturing industries, or manufacturing and distribution also you can say, manufacturing and distribution is largely controlled by the state, in which ownership of the resources, manufacturing and distribution is largely controlled by the state. That is basic definition. However, Supreme Court has clarified that India follows democratic socialism. However, Supreme Court has clarified that India follows democratic socialism to achieve egalitarianism. Democratic socialism to achieve egalitarianism. Right, that is based This part you are writing. Now, how do you say the example? Clarify below. Successive governments have implemented multiple welfare programs. Successive governments have implemented multiple welfare programs to improve vulnerable sections, eradicate poverty. To improve vulnerable sections and eradicate poverty. Some landmark schemes you write. For example, to improve vulnerable sections and eradicate poverty. Example, reservations, MG Narega, Swachh Bharat, whatever, some 2-3 major ones here. PDS, most important, National Food Security Act. MG Narega, Swachh Bharat, PDS or National Food Security, etc. Midday meal, so many are there. And that is, yes, of course, we are doing so many things. Then how counter what you have to write? However, criticism part. However, post 1991, private sector dominates the economy. Post 1991, private sector dominates the economy. Income inequality has increased. Bracket Oxfam report. Private sector dominates the economy. Income inequality has increased. Remember, top 1% owns almost 50% of India's wealth. Oxfam report. Fine. Oxfam report. And what has increased? Regional imbalances has increased. It's a threat to India's socialism. We are not blaming any party, anything. It's overall in general. Regional imbalances has increased. That is other angle. Then secular. Again, same pattern you have to follow. Secular. First write the basic definition. The idea is borrowed from France. Idea is borrowed from France. And what is the basic definition? There should be or there is no official religion for the state. There is no official religion for the state. You cannot write details of what is French and all those things. Clarify in one statement below that. While France follows rigid, strict secularism or strict separation between religion and state, while France follows strict separation between religion and state, while France follows strict separation between religion and state, India follows, the keyword is what? Equal respect or treatment, principal distance, any words. India follows equal respect or treatment for all religions. Sarva dharma samanvaya. Equal respect or treatment for all religions. If you want that keyword also write, that is Sarva dharma samanvaya. Sarva dharma samanvaya. Right? Remember that question also you have. What can France learn from India's secularism? That's actually that detail we'll discuss later. Okay, if you want, you can sum up also. Then comes your example wise. Example. Article 25 to 28 upholds secularism. 25 to 28 upholds secularism. 29-30 provides special provisions for minorities. 25 to 28 provides freedom of religion also you can say, and 29-30 provides special protection for minorities. 29-30 provides special protection for minorities. Correct? Now that is positive angle. Then what is the criticism angle? However, politicization of religion, communal riots are threats to secularism. then democracy. Same structure you have to follow. Same, that question pan secularism will write here itself then. Democracy. Again, first write basic definition. What do you mean by that? Political system based on the idea of popular sovereignty. Keyword again. And the moment you write that, underline. Political system based on the idea of popular sovereignty. Based on the idea of popular sovereignty. Idea of popular sovereignty. India is an indirect democracy. India is an indirect democracy with few features of direct democracy like Gram Sabha. You can't write what do you mean by referendum, plebiscite, everything here. That's not, the space doesn't allow that. India is an indirect democracy with few features of direct democracy like Gram Sabha. Few features of direct democracy like Gram Sabha. Right, then political, next point is what? Political, social and economic democracy is present in India. Examples or positive angle you are writing. Political, social and economic democracy is present in India. Fine, broadly you link. Universal adult franchise. Article, the moment you write that, 325, 326, both you should write. UAF, Universal Adult Franchise, 325, 326. 325, 326. Free and fair elections. Free and fair elections. Upholds political equality or political democracy. Upholds political equality. Upholds political equality. Then below, write the positives. According to UNDP, United Nations Development Program, India has uplifted 40 crore people out of poverty in 20 years or 15 years. 40 crore people out of poverty between 2005 to 2020. Between 2005 to 2020. When according to Niti Aayog, around 10% Indians live under, only around it has come down to, according to Niti Aayog, only around 10% Indians live under BPL. Fine, then, now the criticism part. However, even today, 18th Lok Sabha fact you write, even today, 13% Lok Sabha MPs are women, ADR. Only 13% Lok Sabha MPs are women, ADR, Association for Democratic Reforms. Only 13% are women. And that is one angle. Two is what? Income inequality. Income inequality has increased, violating economic democracy. Income inequality violating, or you can say compromising. Income inequality has increased, compromising economic equality or economic democracy. Fine, that is for all the keywords. Then for everything you have mentioned, but specifically that keyword you have to mention, clarify below. Despite various criticisms, even today, all the adjectives are defendable. All the criticisms, even today, all the adjectives are defendable. In fact, If it was a 15 marker, what you could have done? What the moment you write certain reasons, what then and there you could have done? Yeah, the certain way forward also you can write that just as a structure you write. Points you can obviously you can write. Say example, some like way forward, and then some each and every one you could have written some measures. You know, so many measures are there, that all if you done automatically it is done. That is your how you could have structured this particular issue. If it's a 10 marker, I think that itself is more than enough. Automatically, are the defendable provision itself, you can write it, because for every point you have written, this itself is as are the defendable point. Yes, SC is continuously you are telling. Clear? Okay, that is one question on preamble. Other question, not directly, but okay, you can say a link to that itself is the link to in a way preamble because secularism angle, but we have put it under which one? Comparison of constitution, because it's comparison between France and India. What can France learn from Indian constitution's approach to secularism? What can France learn from India's approach to secularism? India's approach to secularism. Obviously, the question is about which one? The question is about secularism angle. So that means structure wise, first you have to start with what? Secularism. What you have wrote there, same definition you can repeat. Secularism is a concept which evolved in France. Secularism is a concept which evolved in France. And what is the basic definition? It is a political system in which it is a concept which evolved in France. It is a political system in which there is no official religion of the state. That's the basic definition is that. It is a political system in which there is no official religion of the state. In which there is no official religion of the state. Fine. Then, globally, there are two models of secularism. Globally, there are two models of secularism. A, French secularism, B, Indian secularism, or Western, Eastern. French secularism, Indian secularism. Now, first what you have to do, you cannot directly write Indian secularism, right? First you have to write France and then India, France model and then criticism, how that can be addressed by Indian model. First write features of French secularism, French or strict or anything. Features of French secularism. Features of French secularism. First point is what? Strict separation between religion and state. Strict separation between religion and state. Means what? You can't, same. Strict separation between religion and state. In other words, religion cannot interfere into state, state cannot interfere into religion. That is first basic aspect. Second aspect is what? No special provisions for minorities. No special provision for minorities. No special provisions for minorities. C. Government will not or state will not manage religious institutions. State will not manage religious institutions or support religious activities. It will not manage religious institutions or support religious activities. Then religious symbols, celebrations not allowed in public place. Religious symbols and celebrations, activities. Religious symbols and activities not allowed in public place. Religious symbols and activities not allowed in public place. Now you have to write the criticism of this model so that you can link to Indian approach. What is the criticism? French model evolved during French Revolution. French model evolved during French Revolution. French model evolved during French Revolution to keep church out of state. It evolved during the French Revolution to keep church out of state. To keep the church out of state. Fine. Now what is the point? It worked well till 20th century or till Second World War. It worked well till 20th century as, what is the reason? Christianity was the only major religion. As Christianity was the only major religion. Christianity was the only major religion. Fine. Next point is what? Post Second World War and increase in globalization. Post Second World War and increase in globalization, religious diversity changed, increased. Post Second World War and increase in globalization, religious diversity increased. Hence what's happening? Hence France model is, or French model is, hence French model is finding it difficult. French model is finding it difficult to adjust to 21st century needs. French model is finding it difficult to adjust to the 21st century needs. Now for that, link it. Now what is the point? Indian model of secularism, is better suited to handle diversity. Indian model of secularism is better suited to handle diversity. Hence, better suited to handle diversity. Hence, France, same words, hence France can learn from Indian model. Hence, France can learn from Indian model. Now, how is that? Those points you have to write. What is that Indian model? First one. First is what? State can interfere in religious matters. State can interfere in religious matters to bring necessary reforms. State can interfere in religious matters to bring necessary reforms. Simple examples are what? Example, Article 17 abolishes untouchability. Then Sabrimala judgment, Shaira Bano judgment. Article 17 abolishes untouchability, and then Supreme Court, if you want, Shaira Bano case, Sabrimala case. Right, that is first angle, first point. Second point, all counter. Second point is what? State can manage religious institutions. Example, HRC departments in state. HRC departments in state government. HRC means what? Hindu Religious Endowments and Charitable Institutions. HRC departments in state government. Like remember in Karnataka we call it as Mujrai Ilaka. HRC departments in the state government. Most of the states have that. State can manage religious institutions. C is what? State can support religious activities. Example, subsidies, Hajj pilgrimage, Kedarnath pilgrimage. State can support religious activities. Activities, pilgrimages. Example, subsidies for Hajj and Kedarnath pilgrimage. Subsidies for Hajj and Kedarnath pilgrimage. course, so many are there. Kumbhmela, Mahamastakabhisheka, all of those things. And then special protections for minorities, 2930. Special protections for minorities, 2930. Then special protections for minorities, 2930. Religious symbols allowed in public place. Religious symbols allowed in public place. Right? So that is why you are telling that hence they can learn from us. Again, broadly sum up, Indian model of secularism supports equal or is based on, Indian model of secularism is based on equal respect or treatment, whatever you wrote for in that secular word, based on equal respect or treatment for all religions, principled, anything you can write, equal respect or treatment for all religions, equal respect or, yeah, then what it follows? It follows the value of, same statement you repeat, conclusion part, Sarva Dharma Samanvaya. It follows the value of Sarva Dharma Samanvaya. Follows the value of Sarva Dharma Samanvaya. Then if you want to link back to Friend's angle, post-independence, India has handled religious diversity in a balanced way. Post-independence, India has balanced religious diversity in a better way. Religious diversity in a better way. Hence, France in a better way. Hence, France can learn from India's experience. Can learn from India's experience. Right here, you don't have to bring Indian criticisms, all those things, because it will become a kind of trap question then. France can learn from India's experience. Then that's a secularism, not directly related to preamble, actually related to comparison of constitution angle, but still it's fine. That's the preamble questions. This one I will not write. Next question, you tell me, see, look at the demand, you will easily understand. Very simple direct question. Again, as I keep telling, every year 2, maximum 2 I can say, 3 I can't tell, 2 is basic question. This is a basic question. No current affairs, no analysis, no judgments, nothing. Look at it directly. Under what circumstances financial emergency can be proclaimed by the president? Subpart 1. Fine, very clearly they are telling you don't have to generate dimensions or anything here. Subpart 1. Subpart 2 is consequences of such decisions. Recall, you don't have to write, I think, because very simple, direct. Recall article 360. Okay, if you don't want to directly, then what you should do? What you should do? Directly don't go to the emergency. What you tell? Constitution provides for 3 types of emergency. Write the basics first. National emergency 352, state emergency 356, and then this. Then you put the subheading, and then you shift to this. Or you can bring the Ambedkar statement. As said by Ambedkar, Indian Constitution provides for emergency provisions to tackle extreme situations to protect India's sovereignty and integrity. And so it's a kind of balance. Normal circumstances truly federal, extreme circumstances unitary. Write all those basics, then come to this. Because remember, the moment you look at it, you should tell yourself, is it category A or B? So look at it, this is very basic. Easily you can write. What if they ask it as a 15 marker? That's a trap UPSC puts. Because as I told, 10 marker content, there nobody can write 15 marker for this. How will you write 15 marker? But they will ask it as a 15 marker, that's a check. Then what you have to do, you can't write 1.5 side, 134 side. If you write that, 4.5. So then what you have no other option, you have to write in and around emergency first and then come to this later. And so, or what you do, First write about basic 3 types of emergency and then write off all this. Then what you do? Other types of emergency, this, that also you have to generate. Or just overall, whatever dimensions what you can write. Like let's say that till now India has still not, till now you don't have a single financial emergency. That shows that Indian government has balanced the financial, what do you call this, health or financial discipline much better compared to countries like Sri Lanka, which has faced, you might have seen that recent issues, or a few years back, I think Venezuela used to face, so many other countries regularly keep facing. That you can write. Or you can also write that what, that Indian financial emergency provisions is borrowed from United States National Recovery Act, which they had used to tackle their Great Depression problem. This is what I am telling. If in case they ask it as 15 marker kind of H1s, directly you cannot address it. It's impossible to write 2.5 sides. How do you write? Practically you can think and tell. There is no way. Same is for Attorney General of India also. There is no way you can write a 15 marker once if you only write one side, because let's say CAG 15 marker you can write, Election Commission 15 marker you can write, Finance Commission 15 marker you can write, Attorney General 15 marker how will you write? NCSC you can write, NCST you can write. UPSC knows that you will write it. That's why they will ask it as a 15 marker. Let's say that's the game. That's exactly the game. Understood? So that way you have to manage. I don't think I have to tell, you know basics, you know what will happen, that president can what, how is it approved, all those points you know. It has to be approved by both Lok Sabha and Rajya Sabha, simple majority within 2 months. Once approved, there is no need of re-approval. It will continue until it is revoked by the president. Those all basics you write it. Then you tell implication is what? That president can issue directions, reduce the salaries of both state government as well as central government employees, including whom? Judges of the Supreme Court and High Court. Government of India, or in other words, president can issue directions to the state governments to reserve money bills and financial bills for the president's assent. All those points you bring, and as I told you, if in case it's 15, National Recovery Act, how Indian government has not considered it even once, that all angle you need to bring. That's the management trick. If it's a 10 marker, I think easily will manage, you can directly write that. Understood, right? Structure part? Yeah. So I don't think, and even emergency, there's no chance of asking a mains question on that. Okay. This angle, look at the question, not a theme for simple reason. It is this kind of topic is not mentioned in your syllabus, but it depends on that year. So that year some issue might have happened, I've forgotten what exactly, but look at it, the question is about easily a 15 marker content. Khaap Panchayats are extra constitutional authorities. They are violating human rights. That angle you have to address first. Then the angle that you have to address is what actions who has taken. Again look at it, 3 keywords. Legislature, subheading separate. Executive, separate subheading. Judiciary, separate subheading. Limitations. Means what? Look at the word. Means despite taking, first is what, how are they violating? Second is even what measures government has taken. Next is even despite measures, why are they continuing? That means there is some loophole. What are those loopholes? If there are loopholes, then automatically what is the next point then? How will you address it? Understood? That is the Khaap Panchayat angle. So this one better you write once, because structuring part you will understand better. But though it is not a theme, you don't get it regularly. Maybe who knows, at least Khaap Panchayats points you can use somewhere. So because the question is about Khaap Panchayats, introduction, address what is Khaap Panchayats. Khaap Panchayats are, again as I keep telling, repeat the keywords mentioned in the question. Khaap Panchayats are extra constitutional authorities. Their Khaap Panchayats are extra constitutional authorities. Extra constitutional authorities which have presence in states like Rajasthan, Haryana, UP, which have presence in the states like Rajasthan, Haryana, UP, parts of West Bengal and Tamil Nadu. And parts of West Bengal and Tamil Nadu. In Tamil Nadu, they call it as Khaap Panchayat. North India, largely it is Khaap Panchayat. That is basic idea. Where is it? All those things. How do they function? Next point is what? They are traditional institutions. They are traditional institutions which function based on. They are traditional institutions which function based on identities like. Traditional institutions which function based on identities like caste, gotra, caste, gotra and patriarchy. Caste, gotra and patriarchy. So that is basic idea. What do you mean by Khaap Panchayats? You are telling. If you at least write this, obviously what will evaluator feel? Okay, fine. You know at least what do you mean by Khaap Panchayats. Now you have to get to which angle? What is the angle you have to write? How they are violating Khaap Panchayats. You, as I keep telling, you can either use a subheading, but here rather than directly writing subheading as Khaap Panchayats and human rights violation, what you can do? Rather than subheading, what you can use? Use a linking para. Khaap Panchayats have violated human rights in various instances. Khaap Panchayats have violated human rights in various instances. Have violated human rights in various instances. Right? Write those. How do they violate all those things? Point number 1. It is largely dominated by the higher caste. Largely dominated by the higher caste, thereby violating rights of. It is largely dominated by the higher caste, thereby violating the rights of other castes. Thereby violating the rights of other castes. In bracket, Article 14, 15, 17 violated. That's the substantiation angle. 14, 15, 17. Then again, who dominates again? It is dominated by men. Hence goes against women's rights. Dominated by men, hence violates women's rights. Dominated by men, hence violates women's rights. If you want again link Article 15, hence violates women's rights, that is Article 15. Then it has contributed to, or it has led to honor crimes in several instances. It has led to honor crimes in several instances. Honor crimes in several instances. Fine. Then next one. They give verdicts. They give verdicts. Hence, violating which one? Rule of law, principle of natural justice. Who gave you the power to give verdict? They give verdicts, thereby violating rule of law and principles of natural justice. Thereby violating rule of law and principles of natural justice. Understood? Have you heard Khaap Panchayats various instances? Like for example, in Haryana there was an instance, it's all very famous ones, wherein the couple was married for 3-4 years, they had a child. Then they got to know that both belong to the same gotra. Then the Khaap Panchayats told, from now on your brother and sister, give the child to the Panchayat. How will you take this? They told that the girls should not use mobiles and jeans and all those things, because the Western culture is whatever, those are same angles, that your women, girl children are losing their values, and all these things they have done. Fine, but still they are very powerful because caste angle is very, very dominant. And lot of disputes they settle. Means what? You know, family disputes will be there, marriage disputes will be there, property disputes will be there, one caste, other caste issue might be there in village. Most of it they settle. So they normally keep functioning. Sometimes it becomes controversial, the issue will come up, especially when it leads to honor crime angle. Right? Okay, largely you have address which one? The first part. Now, what measures have been taken? Actions that you can use as subheading also. Actions taken by various organs. Then you go to legislature, executive, judiciary. Actions taken by various organs. Under that, legislative measures. Legislative measures. First is what? Obviously, Panchayats established by 73rd Amendment 1992. Panchayats established by 73rd Amendment 1992. 1982. First measure. Obviously, that is all to replace this Khaap Panchayats. 2. Second one is what? Gram Nyayalayas to resolve local disputes. Remember Gram Nyayalayas Act 2008. Gram Nyayalayas to resolve local disputes. Gram Nyayalayas to resolve local disputes. Then Grama Sabha to take any decisions at the village level. Gram Sabha to tackle any decision at the local level. Right? But what is the limitation? Limitation you mentioned. Law Commission drafted a bill. Law Commission drafted a bill to declare Khaap Panchayats as unconstitutional. Or to mention the judgment, I mean, what do you call this? Punishment, everything. Drafted a bill to declare Khaap Panchayats, but unfortunately what happened? However, the bill was not passed. However, the bill was not passed. However, the bill was not passed. That's critically analyzing you are letting the limitation. To second angle is what? Ineffectiveness of panchayats. Ineffectiveness of panchayats. Ineffectiveness of panchayats makes Khaap Panchayats more stronger. Ineffectiveness of panchayats makes the Khaap Panchayats more stronger. Makes the Khaap Panchayats more stronger. Then executive. Executive measures means government angle you have to write, like punishment, all those things. Executive measures. Executive measures. First one, strict enforcement of IPC. Strict enforcement of IPC to address honor crimes, caste atrocities. Strict enforcement of IPC to enforce honor crimes, to address honor crimes and caste atrocities. If you want, actually you can write other angle also, which is what? Second one is SC/ST Prevention of Atrocities Act, which is a legislative measure also. When you write executive angle, talk about implementation. SC/ST Prevention of Atrocities Act. SC/ST Prevention of Atrocities Act. Then welfare schemes to improve. Welfare schemes to improve the vulnerable sections. Of course, women rights. To improve the vulnerable sections. Right? Then NCSC, NCW, NCST, NHRC for that matter, NCSC, NCST, NHRC, NCW to uphold rights, whatever those rights, vulnerable rights, to uphold the rights of vulnerable sections. Right? Total measures taken, but what is the loophole? However, in practice, Khaap Panchayat still remains strong. In practice, Khaap Panchayat still remains strong as there is a nexus with police. As there is a nexus with police, and conviction rate is very less. Right, then judicial measures. Judicial measures. Supreme Court has declared Khaap Panchayats as unconstitutional. Supreme Court has declared Khaap Panchayats as unconstitutional. Khaap Panchayats as unconstitutional and honor crimes as a rarest of the rare case. That means what then? Death penalty. Khaap Panchayats as unconstitutional and honor crime as the rarest of the rare crime. Hence, death penalty. Hence, death penalty. Right? But obviously, what is the loophole? However, judicial pendency, rigid procedures, inefficiencies of subordinate judiciary, subordinate courts, inefficiency of subordinate courts have contributed to inefficiency of the subordinate courts have contributed to the continuation of Khaap Panchayats. Understood? So that is structure part. Then overall broader conclusion. Presence of Khaap Panchayats indicates social political support to such institutions. Indicates social political support to such institutions. Social political support to such institutions. It violates the vision and values of the Constitution. It violates the vision and values of Constitution. We need comprehensive measures. We need comprehensive measures to completely deroot such institutions. We need comprehensive measures to completely deroot such institutions. Completely deroot such institutions. Right? Okay, so that is broadly the Khaap Panchayats angle, which is, as I told, it's not a theme. This is to understand how to structure when they are asking, see, legislative, executive, judiciary, all three separately you need to address. Because they are asking critically, write the measures, then write the criticism. Then you have to conclude. Understood? All the keywords in the question you have to address. You cannot directly jump to measures. It doesn't work like that. Without writing how they are violating fundamental rights or human rights, how will you write the measures then? Logically it doesn't work. Understood? Okay, so that means which part is left out then? The most important parts like which one? Basic structure, constitutional morality part. That we'll do tomorrow. This one, which is related to basic structure, morality. This is also in a way amending the Constitution. So that part, amendment of the Constitution part, actually basic structure, morality part. That if we complete, mostly the first part, the basics part and the first subtopic will be done. Of course, after on this, probable questions also are there few. I think I've done some maybe 5, 6, I've forgotten exactly. I'll upload that PPT. You have to download, you don't have to take a printout or anything. What we'll do is, either in your laptop or computer, anything you keep in this tab or mobile you keep it, but I will not, because normally what I have seen last 1 or 2 years is that when we give those PDFs of or PPTs of that also, what students will do, again the same, they'll keep that. Again it's ultimately the same, no? Well, that's what I'm telling, you should have it written. That is when you can revise, I'm telling. That's why last time also I decided, I'll show that PPT one, but what I'll do, I'll sum up and then I'll make you write here itself. Because experience I have seen that it will become another monthly magazine. So it is still the same. So hence you have to note it down. I will dictate that also, core crux and everything. They would have, that I'll upload it anyhow in maybe today or by tomorrow morning. I'll upload that. Clear? I think they have already put the timings. Morning session will be there. Okay, so is that fine? So largely because in the normal OGP classes we'll be mostly focusing on the basics part. Here we'll more focus on the writing part and the mains part. Yeah. Why? Any issues? Other classes going on? One stretch. See, one stretch, the issue is availability of class is one issue. Two major issue is my throat issue. Because imagine how much effort I have to see normal basic classes. You can take time. I can explain some examples, some stories will be there. But here, no story, no example. Directly I have to tell, and it will put a lot of stress. So that's why I have told them deliberately to give me at least 2-3 hours gap between two classes. It will put a lot of strain. I don't know if you can imagine or not. Yeah. So you don't have other classes, right? Then I have to adjust a little bit because there is no other option. How many classes? On an average, I can tell you around 12, 13 class. So the mine will take polity, governance, social justice will take around 10 or 9. It depends, 9 to 10 class. IR will take around 3 or 4. Around, you can assume 80 to 90 hours. So it depends on how quickly you write. The more quickly you write, it's more easy for me. Yeah. Okay, we'll meet tomorrow then.